Hey everybody, this is Patrick Hindman with Sunrise Law Group. There are two ways, and it depends, well, actually three. How is the bank account set up? Is there a survivorship? Is there a survivor beneficiary? As in, often you'll have, say, checking or savings accounts where a wife and husband are both on there. Those usually have, are done in the same vein as like a tenancy with the right of survivorship. When one dies, the other one is still there with access to the account. Now, if it's an account that is wholly run by one person, the decedent, or wholly in that person's name, it could either be, there could be a survivor benefit in terms of a payable on death provision where it says, hey, I died. This is going to be a specific payable on death beneficiary. On my death, this person has access and inherits this account. If that does not exist, then you need letters of administration or letters testamentary, which would mean that we've either probated a will to get letters testamentary. Letters of administration means we're in an intestacy administration, and they both serve the exact same purpose. They're just called different things because one involves having a will, one doesn't. But the reality of it is the bank's not going to they're going to freeze that account, and they are not going to, a bank or if you got like a brokerage account with a Merrill Lynch or Fidelity or something like that, as soon as you tell them that person has passed away, they are going to have very strict provisions. And only real way around those, depending on if there is no sort of beneficiary designation on the account or the account was not joint with any form of survivorship, is you're going to need to have letters of administration or letters testamentary, which again, in this sense, are the same thing. They just go for the two different types of administration. Let's now talk about selling a piece of real estate that is owned by an estate. Well, it depends on how you've done your administration. I mean, do you have a lawyer helping you with doing the administration? You can sell it, but you need to wait till you've opened up a probate administration unless the property has a survivor benefit to it. If it does not, if the property was titled and deeded in the decedent's name solely, then it passes according to what the will says or under the rules of intestacy immediately on day of death. But it's subject to an estate lien for the 6-month statute of non-claims. So basically, you can sell it, but it has to go into your estate account until all claims and creditors have been paid. And like I said, that is if there is no survivor benefit on the deed on its face. If there is a survivor benefit, then it goes to that person who has the survivor benefit. Say you have a husband and wife that own, a beach condo as tenants in common with the right of survivorship. Husband dies, wife inherits it on day of death. It's outside of probate. She's got it. Okay. If it's just husband owned it, wife's not on the deed, hey, it goes straight into becoming a probate asset. And like I said, but unlike personal property, real property is technically inherited day of death, but is subject to estate liens, which would be for the 6-month statute of non-claims, where you have given notice to known creditors and also given constructive notice through newspapers, whatnot. And there's a list of those that you can pick from when you go to file in probate court to open the administration. But the bottom line is you can sell it. There's no problem with that. It's just where the money goes. Thanks for watching. If you have any questions, please don't hesitate to reach out. Thank you.